Engrossed committee substitute for House Bill 4012, West Virginia Religious Freedom Restoration Act, second reading of the bill.
Are there amendments to the bill?
Yes, sir. The Committee on the Judiciary moved to amend the bill by striking out everything after the enacting clause.
Senator from Morgan.
Thank you, Mr. President. I ask unanimous consent to be able to explain the amendment in lieu of having it read.
Senator from Morgan requests unanimous consent to explain the amendment in lieu of having it read. Is there objection? Chair hears none, so ordered. The Senator from Morgan.
Thank you, Mr. President. Although let me disabuse everyone of any illusion that this will be quicker than reading it, because I intend to go through it, if I may, section by section. The Judiciary Committee's amendment is a strike and insert amendment for the entire House bill. And what I am planning to do, if with the body's indulgence, is just go through the Judiciary Amendment section by section and highlight for the members where the differences are between the Judiciary Committee's amendment and the House engrossed bill, and perhaps the House introduced bill as well when it's applicable. Both the strike and insert amendment and the House bill create a new article, would create a new article in the West Virginia Code. It would be Article 11C, located in Chapter 5. The Judiciary Committee strike and insert amendment has 7 sections. It's a little longer than the original House bill, which had simply 5 sections. There are 4 sections in both that are sort of similar. The House had 1 section, we do not, a separability section. And the Judiciary Committee's amendment had 2 sections. There's sections 6 and 7 of the strike and insert amendment that are different from the House bill. Section 1 in both bills is the short title for the act, and there's a difference there. The House bill was called the West Virginia Religious Freedom Restoration Act. The Senate strike and insert does not call it Religious Freedom Restoration Act, or RFRA. It is called, under the Judiciary strike and insert, the West Virginia Religious Freedom Protection Act. And the thinking behind the use of the word protection as opposed to restoration is simply that there's nothing to restore in West Virginia. The constitutional rights of freedom of religion guaranteed under the U.S. Constitution and the West Virginia Constitution exist fully in West Virginia. And so we don't call it the Restoration Act. That actually comes from the original Federal Act, which was enacted by Congress after the Smith case as a response to the decision in the Smith case. But we have had no such decision here, so I think it's accurate to say we're protecting rather than restoring. Section 2 of the Senate bill is the strike and insert is purposes section, delineates purposes of the act. It is very similar to the engrossed House bill. In fact, it is identical but for a couple of things. The Senate strike and insert refers to the affirmation of rights of West Virginians under Article 3 of our state constitution and under the First Amendment to the United States Constitution. And the House bill does not mention, for some reason, I don't know why, but it does not mention the rights guaranteed under the United States Constitution. So that's a difference. There's another subtle difference, and you'll see this, if I forget to mention it in each section, just pretend now that I've said it with each section. The Senate strike and insert refers to governmental action. The House bill referred to state action. It seemed to me and others to be more accurate to refer to governmental action as opposed to state action because there are references in the bill to local ordinances. And so technically, it seems to me, although I guess in an expansive view of what state action means, it could include local ordinances, but governmental ordinances clearly, or local government ordinances are clearly within the scope of what anyone would think of as governmental action. So that's a difference that is evident in Section 2, and it's in other sections of the bill as well. Section 3 in both bills, the Senate strike and insert and the House bill, are definition section. So, in both, there is a definition of exercise of religion. And although there were earlier versions of a Senate piece that had a different version, this, which was adopted by the Judiciary Committee, I believe is identical, the definition of exercise of religion in the Senate strike and insert, to the definition which is contained in the House bill. In Section 3 of this, both the Senate strike and insert and the House bill, the engrossed House bill, there is a definition of, again, in the Senate strike and insert, Judiciary strike and insert, it's governmental action. In the House bill, it's state action. But I think, other than the nomenclature, what we call it, they're the same, or very close to the same. Well, no, I take that back. There is a subtle difference. The House bill refers to persons acting under color of law. The Senate strike and insert refers to a person or entity acting in an agency capacity. We had some discussion in committee as to what the difference was. I believe actually the Senate strike and insert is broader. Okay, but within Section 3 in the Senate strike and insert, there's an additional definition. There's a definition of substantially burden, and that is not in the engrossed House bill. So while both bills refer to governmental actions or state actions which substantially burden persons' sincerely held religious beliefs, the House bill does not provide any definition of what that means, what it means to substantially burden someone's sincerely held religious beliefs. The Senate strike and insert does. It's a definition actually that was taken from the Religious Freedom Restoration Act that was enacted in the state of Pennsylvania. This is almost verbatim what Pennsylvania adopted when they adopted a Religious Freedom Restoration Act. And there are four, as you'll see, there are four different things here. They're in the disjunctive. In other words, you don't have to have all four to substantially burden someone's religious beliefs. It's any one of the four under ours. Now, as I said, the House bill passed to us does not have a definition of substantially burden in it, although I would note that the original bill in the House of Delegates, the introduced bill, did, and it was stricken at some point along the way in its progress toward passage to this body. Section 4 of both bills is really the heart and soul of the legislation. Section 4 provides the applicability. Both have the same heading. It's the construction of the article and the test. And what both and I don't know that there's any significant difference between the House bill or the Senate strike and insert as to that. Well, there may be some around the edges, but let me get to the main part of it. The main part of this Religious Freedom Protection Act, as we have it, or a Religious Freedom Restoration Act, as other entities have passed it, is to establish a test regarding how courts are to adjudicate cases when governmental action, it applies to governmental action, substantially burdens a person's sincerely held religious beliefs. So really, the structure of it, the way it works is it's a four-part test. There has to be governmental action. It has to substantially burden a person's sincerely held religious beliefs. And if it does, then the remainder of the test is there a compelling governmental interest? Does the government, it's for those who study constitutional law, it's the strict scrutiny test that has been imposed and required by our U.S. Supreme Court when the fundamental constitutional rights of people are involved or under scrutiny. So the government has to be able to show a compelling state interest for its action, which is burdening or allegedly burdening someone's sincerely held religious beliefs. And then the second part of that, half of the test, is that the action is the least restrictive manner for the government to accomplish whatever it is that's in the that is decided to be, if it is, a compelling governmental interest. And that test is what's embodied in Section 4, both of the House bill and the Senate strike and insert. And that is really subsection A. If you go to subsection B of the Senate strike and insert, there are some differences in the relief that can be afforded between the House bill and the Senate strike and insert. Under the Senate strike and insert amendment, remedies are limited to injunctive or declaratory relief, or as a defense in a judicial or administrative proceeding. Under the House bill, it's a little broader, and the remedies are injunctive and declaratory relief, reimbursement of costs, and attorney's fees. So, the House had language in theirs that said nothing could be construed to create a cause of action against a non-governmental employer. We deal with that in the Senate strike and insert separately, and it's actually in the final section of the bill. I think that at least there's some overlap there in Section 7, subsection B. The Senate strike and insert says nothing in this article should be construed to create a cause of action for monetary damages. There is language in the House bill that says nothing in this article may be construed to constitute a defense to a claim based upon a refusal to provide emergency medical services. We have language in subsection C of Section 4, which is very similar. It says nothing in this article may be construed to constitute a defense in any cause of action based upon a refusal to provide emergency medical treatment. And the difference between treatment and services is only that I think that emergency medical treatment is a term that is used in our code in another article or chapter. Okay, subsection D of the Senate strike and insert says the article does not apply to local or regional jail, state or federal correctional facility, or any facility that treats civilly committed sexually violent offenders. And that language is, if not identical, very similar to the final sentence of the House bill, subsection C. As said, Section 5 in the House bill is a severability clause. There's not one in the Senate strike and insert, deemed by me anyway to be unnecessary because there's a general severability clause that exists in Chapter 2 of our code. And so I think actually the effect of the severability clause in Section 5 of the House bill probably narrows the severability rather than expands it. There are other sections in our bill which are not in the House bill. We have Section 5 in our strike and insert that says a person's free exercise of religion shall apply equally to churches and religious institutions in or through which persons exercise or express religious faith, including their pastors, ministers, priests, rabbis, other clerics. Section 6 of the Senate strike and insert delineates a few specific actions that government is precluded under this strike and insert amendment from doing. And it says simply, no governmental entity. So that's no state government, no board, no local government, no county, no municipal government may, 1, compel a church or religious institution or cleric to perform any sacrament, ceremony, practice, ritual of its faith against his, her will. There are 3 others in here. There's a clause that says specifically the government cannot compel a minister of any church to marry someone if it violates the or recognize a marriage if it violates the tenets of that church or faith. The final section of the Senate strike and insert is entitled Scope of Article Legislative Intent. Again, there's not a similar text in the House bill, but we felt, I think the committee generally felt, that it was important to adopt, worth adopting, to clarify that it is not the intention of the legislature to allow or enact a Religious Freedom Protection Act that can be used as a tool of discrimination. The proponents and opponents of the Religious Freedom Protection Act or Restoration Acts that have been enacted have argued, the proponents, that it does not allow discrimination, the opponents that it does, and it seemed like it would make sense to me to have a section in here that says what this says. And if I may, Mr. President, I'll read it. In subsection A, it says, in enacting this article, it is not the intention of the legislature to expand or diminish the rights of persons under the Constitution of the United States, the Constitution of West Virginia, the laws of the United States, the laws of the state of West Virginia, or ordinances enacted by political subdivisions of the state of West Virginia. Rather, it is the sole intention of the legislature in enacting this article to codify the test and standard of review under which governmental actions are to be judicially reviewed when those actions are alleged to be substantially burdening to one person's sincerely held religious beliefs. And so I don't know that says it perfectly, but what I hope that section embodies is the idea that what this article is it establishes a test by which the various rights are balanced and under which they must be balanced when they come into conflict. But it's not the intention of this article to declare a winner or a loser preemptively in any case, to expand or diminish anyone's rights, but rather just to provide for the test under which these are balanced. So with that, Mr. President, I'll be happy to answer questions or sit down. I know that there have been filed amendments to the amendment, so however the body wants to handle those.
Clerk has an amendment to the amendment.
Senator Gaunch moved to amend the amendment on page 1, section 1, line 1, by striking out the word
Junior Senator from the 8th.
Thank you, Mr. President. I request unanimous consent to explain the amendments in lieu of having them read, and that all the amendments be considered as one.
Junior Senator from the 8th requests unanimous consent to explain the amendment in lieu of having them read, and that all the amendments are to be considered as one. Is there objection? Chair hears none, so ordered. The Junior Senator from the 8th.
Thank you, Mr. President. This really looks like it's a complicated amendment, but truthfully it's very simple. And first I'd like to say that I have great respect for the deliberations of the Judiciary Committee and its chairman, and I'm part of that committee. I'm proud to be. The reason, though, for this what looks like a complicated amendment, and the very simple part of it, is that the amendment seeks to replace the strike and insert amendment from the Judiciary Committee and reinsert the language that came over to us from the House. Reason being, from my standpoint, that body deliberated hours. In committee and on the floor, they voted 72 to 26. I think they produced a very good bill, a bill that I don't think needed fixing. It had strong bipartisan support, and I'd like to see us return to that and vote on that. I'd like to reserve the closing, please, and I'd like to demand the yeas and nays.
Is there discussion? Senior Senator from the 4th.
Can I have the Judiciary Chair yield, since the motion is to change the language?
Will the Senator yield?
Yes, sir.
I'm trying to understand something because it's in the purpose section of at least what I found on my system. It says the purpose of this bill is to codify the compelling interest test and strict standard test set forth, and then it lists 3 cases. It lists a 1963 case, a 1972 case, and a 1966 case, which was actually a West Virginia case. Can you give me a brief synopsis of what those were all about? Because it's like this law its purpose is to codify actions that arose from these cases. So if we know what those cases were, it gives a little bit of insight as to what should be coming next.
To my good friend, the Chairman of Finance, I don't know all the facts of these earlier cases. What I do know is that they are cases that challenged, were the religious freedom challenges decided upon the basis of strict scrutiny. The compelling state interest test and whether or not there's a less restrictive alternative that is codified and set forth in Section 4 of the bill. And they stand opposite the case that the U.S. Supreme Court decided that gave rise to the federal RFRA. Because the U.S. Supreme Court in the Smith case did not utilize that standard. If the gentleman remember, it was a case from Oregon, I believe, that arose upon the question of whether or not an Indian tribe, as part of its religious culture, could smoke peyote. And ultimately, the U.S. Supreme Court determined that it was not in violation of their religious rights for the government to preclude that. So that's what gave rise to...
So they weren't allowed to smoke the peyote, in other words?
Well, now...
Is that what happened?
At the federal level, that gave rise to the RFRA. The Congress, I would say it's early 90s, I think, late 80s or early 90s when the Congress enacted the federal RFRA. And probably, I think, within 5 to 10 years after that, there had been a case before the U.S. Supreme Court in which the U.S. Supreme Court said that the Federal Religious Freedom Restoration Act applied only to federal governmental action, not to the states, but that states could certainly enact their own religious freedom protections. So the West Virginia case, as I've come to understand it, that's cited there, State versus Everly, does stand for the proposition that strict scrutiny is a standard that applies in West Virginia when a person's sincerely held religious beliefs are being burdened, substantially burdened by governmental action.
So the person who's saying my religious beliefs are being violated, you have to, is that who's being scrutinized strictly? Sorry to be so ignorant of this, but not being on the committee, when you say that strict scrutiny, I can hardly say that, standard, how's that work? Is that something being applied to the state or being applied to the individual that's, are you scrutinizing me or what is that? Can you give me an example of?
Well, I got the head note from the Everly case now. Syllabus .2 from State versus Everly.
All right.
It's cited at 150, West Virginia Reports 423. 146 Southeast 2nd, 705. It's a 1966 case. The Supreme Court's holding in syllabus point 2 is the refusal of a citizen to serve as a juror because of personal conscientious objections based upon his personal religious beliefs is sufficient under ordinary circumstances if there is no question of the sincerity of such beliefs to come within the purview of the freedom of religion provision of the First Amendment to the United States Constitution and Article 3, Section 15 of the West Virginia Constitution, and does not justify a conviction for contempt of court where there's no indication that such refusal would affect the peace and safety of the state, and there is no showing that an adequate number of competent jurors could not be obtained otherwise in order for the state's interests to be protected. So there you had a person, I assume a fellow, I don't know, a person said, I can't serve on a jury. It will burden substantially my religious beliefs to do this, and got held in contempt. So threatened with governmental action, contempt could be fine or incarceration, and the case arrived at the Supreme Court. I don't know whether it was a direct appeal or a writ, an extraordinary writ, but the Supreme Court applied what we're talking about here as a strict scrutiny test. Does the person have a sincerely held religious belief? Is it being burdened, substantially burdened by governmental action? Then if so, the test is there a compelling state interest? And so I think the court answered that in this way by saying that it wouldn't, well, you know, I think you could even say, even if you agreed that there were a compelling state interest, and there probably is, in being able to get jurors together to do justice in a case, it would appear to me the court decided that case on the fourth part of the test. In other words, there's a less restrictive alternative. You can impanel a jury by getting some other people together who maybe aren't, whose religious beliefs aren't burdened.
So you're telling me that back then this person prevailed and their religious freedom was protected and they were not compelled to serve on that jury by the decision of the court. Is that correct?
Yes.
And that happened when? In 1966?
That case is reported from 1966.
And so then what this bill then must be doing is, though it appears that a citizen has already won a religious freedom case without a religious freedom law. Is that what I'm hearing?
Clearly, yes.
Was it said on this point then, because it did reference the, and I've got it open here, the, what is it, Article 3, Chapter, Section 15, the religious freedom guaranteed in the West Virginia State Constitution. Was it said by anybody in committee that our religious freedom section of our Constitution was one of the most, what's the right word?
Strongest and explicit.
Strongest in the country.
I don't know if it's the strongest in the country.
But it's strong and explicit.
It is, and you know what? It is beautiful. It is beautifully written, and if you'll indulge me, I'll read it. You read it. Article 3, Section 15. It's much stronger than the protections of the First Amendment to the United States Constitution, although it is not politically correct on a gender basis. It says, no man shall be compelled to frequent or support any religious worship, place, or ministry whatsoever, nor shall any man be enforced, restrained, molested, or burthened in his body or goods, or otherwise suffer on account of his religious opinions or belief. But all men shall be free to profess, and by argument to maintain their opinions in matters of religion, and the same shall in no wise affect, diminish, or enlarge their civil capacities. And the legislature shall not prescribe any religious test whatsoever, or confer any peculiar privileges or advantages on any sect or denomination, or pass any law requiring or authorizing any religious society or the people of any district within the state to levy on themselves or others any tax for the erection or repair of any house of public worship or for the support of any church or ministry, but it shall be left free for every person to select his religious instructor and to make for his support and such private contract as he shall please. It really is beautiful.
And it flows out of our heritage of being West Virginia, from Jefferson,
and I'm embarrassed to say, I should know, I don't know if any of that comes also from the Virginia Constitution.
Well, I think it does. But so what I'm hearing you say is that the purpose of this bill would be to codify, meaning let's put it in statute what we think the court did, or what the court did in 1966 in this one bill. And I'm going to make an assumption, though, that the other two cases probably were cases, would you say, although it would be good to know, but would you say were people that won religious freedom in a court decision somewhere where they were not substantially burdened, or strict scrutiny was applied in each one of these cases, and the citizen prevailed, and then that this law is to take what happened in those three instances and build our state law around it. Is that what I'm reading as the purpose stated in this bill to do? Is that correct?
I'll say yes with one caveat. And that's the misconception, I think, that is one of the misconceptions that is tied to this legislation. It doesn't mean the citizen asserting that his or her religious beliefs have been substantially burdened always prevails. That's not the case. And what this statute will do will codify the test used in those cases to determine who wins or who loses, but it doesn't predetermine who wins or who loses.
Yes, because it says, technically, it says the compelling interest test and strict scrutiny standards set forth in these cases. Not there was a standard that was used in these cases, but this standard flows out of these cases. Am I reading that right?
Yes, and I think that's, by the way, since we're debating the amendment offered by the gentleman from Kanawha, I think that's the same in both.
Well, but it affects my opinion on deciding the amendment to know whether or not your version of the Judiciary Committee's version of applying this purpose is more consistent with the stated purpose or the amendment's stated purpose. That's what and not being on the Judiciary Committee, I realize I'm almost doing committee work, but I know this is an issue of some weight, and there's a lot of people that are torn up over this in our state and in this building. So I'd like to know how, if you can, I don't know if you can give me an answer to this question.
Well, I've got the Sherbert case up here now on the screen. And the Sherbert case is decided by the United States Supreme Court, and the cite for it is 374 U.S. 398. It's a 1963 case. Adele H. Sherbert, appellant, versus Charlie Varner and others as members of South Carolina Employment Security Commission and Spartan Mills. And it's a Justice Brennan decision. The appellant is a member of the Seventh-day Adventist Church, was discharged by her South Carolina employer because she would not work on Saturday, the Sabbath day of her faith. When she was unable to obtain other employment because from conscientious scruples she would not take Saturday's work, she filed a claim for unemployment compensation benefits under the South Carolina Unemployment Compensation Act. And then there's great discussion of how that act is structured, et cetera, et cetera. But the Supreme Court of the United States applied the strict scrutiny test in this case.
And did she get her comp benefits?
I believe she did.
So she was able to get her comp benefits.
Whoops, that ran away from me there.
By claiming the Sabbath, it was her sincere belief, got her comp benefit.
Yep. Now, the Wisconsin versus Yoder case, which is cited in that section of both the House bill and the Strike and Insert Amendment, is a 1972 case, and it's cited at 406 U.S. 205. And in that case, the United States Supreme Court held that Amish children could not be placed under compulsory education past 8th grade. So that case arose out of Wisconsin, and the court used the strict scrutiny test and analyzed the fundamental religious rights, freedom of religion rights of the. And so these cases predate, all of them, the two federal cases we just looked at, and the West Virginia case. They all predate the Smith case and the Federal Religious Freedom Restoration Act. This was the standard, the strict scrutiny standard.
And did the Smith case then do something, as you lawyers all say, did it change the precedence?
It refused to apply strict scrutiny. The court there refused to apply strict scrutiny and afford any deference to the Indians who had peyote as part of their...
So then this bill then, and I'm sorry to take so much floor time, but then this bill then tries to go back and say there was a standard applied in these cases that we need to codify because this standard is not assured to our citizens if their religious freedom is violated because of this Smith case. Is that what's being said?
Well, I'll go part way there with you. I will say that we have not had in West Virginia, to my knowledge, a case like the Smith case where our state Supreme Court has said, you know, we're going to apply a different standard to the evaluation.
So we're trying to fix a problem that we don't know that exists yet.
You know, I think for many people who care deeply about religious freedom, it's important to have it not only in this beautiful language that's in our state constitution, but also in statute as an instructive manner to give courts guidance on how they adjudicate the standard under which they should adjudicate cases. But we're circled back around to the reason why the Senate version calls it the Religious Freedom Protection Act as opposed to the Restoration Act, because you can only restore that which has been lost.
So we don't know if it's lost yet or not in our state. But then finally, and maybe this is can you make, okay, now that we've spent probably 10 or 15 minutes on the purpose, and I think I've gotten now a sense of what the purpose is based on this explanation, then do you believe that your committee substitute more consistently fits the purpose of this bill as it's stated than the amendment that has been made to replace it with another set of words or other language?
I will say that I think both fulfill the purpose. I think the Senate Strike and Insert Amendment fulfills the fundamental purpose. Clearly, I agree the House bill, and we are now back around to the subject immediately under debate. The gentleman from Kanawha's amendment, as I understand the amendment, would basically return what this body is considering to the bill, or something very close to the bills that arrived here from the House of Delegates. I think they both address the purpose. What I like, and the reason that I would resist the amendment offered by my dear friend and the gentleman from Kanawha, is that and I am just stuck on this language that we have in our Strike and Insert Amendment in Section 7, which I hope will be read as it's intended as a salutary message to people who are concerned that our body is adopting something that could be used as a tool for discrimination, which I would abhor. That would be horrible. And I don't think there's any member of this body or this legislature that wants to do anything that is unfairly discriminatory to any citizens of West Virginia. And I'd like this Section 7 because it's an effort to say that.
Yes, I'm reading it. So it's not the intention of the legislature to expand or diminish the rights of a person under the Constitution, U.S., state, West Virginia. That's the right section I'm reading.
That's it.
Okay.
Rather, it's the sole intention of the legislature in enacting this article to codify the test and standard of review.
So you would say that let's go back to those three cases: the Sabbath person and the Amish children and the person who did not want to serve on the jury. They would probably be okay with that. There's nothing about this that removes their right to bring a religious freedom argument to us if that happens similarly here. Is that
are you
correct?
talking about the Section 7?
Section 7, there's no discrimination there.
No.
Okay, so...
And certainly none intended. That section is intended by me to be a salutary message.
Can I ask, or maybe there's not a good... Who is envisioned in terms of well, maybe that's not a fair question, but why is... I don't understand the concern why, given these examples that we've already seen, why this... I guess I'll listen to the argument on the other side, why this isn't safe, why this isn't stating our intent that why this isn't good. I mean, to me, it appears your work product is good. So, thank you very much, Mr. President. I was trying to establish what the purpose was and how the language has applied the purpose. So, I'll sit down now and listen to the rest of the floor debate.
Is there further discussion? A senior senator from the 16th.
Thank you, Mr. President. Would the junior senator from the 17th yield for a question?
Junior senator from the 8th.
Or the 8th, I'm sorry.
Will the senator yield? Senator yields.
Glad to.
Senator, I just want to make sure I understand this amendment. Your amendment to the strike and insert amendment would take it back to the original House bill. Is that correct?
That's correct.
So my question is, so why would you make an amendment to an amendment and not just go against the strike and insert and vote the strike and insert down? Because if the strike and insert is voted down, then we are left with the original House bill. Is that correct?
You know probably better than I'm not sure.
I believe that's the case. So what you're trying to accomplish is, if you don't like the Judiciary's amendment, strike and insert, to the House bill, then by voting down the Judiciary strike and insert leaves the original House bill before us. So this is very unusual to have an amendment to an amendment that takes it back to the original, that the original amendment, if failed, would take us back to the original anyhow. And I'm just wondering what the strategy here of all this explanation, because I think life would be a little bit simpler that if you didn't like the strike and insert from the Judiciary Committee, all you have to do is vote down the strike and insert, and we're left with the original bill, and that's what we would be with. This gives you kind of, I guess, two bites at the apple, right? I mean, if your amendment doesn't pass.
I guess you could say that. You say it's unusual. Is it unusual wrong or just unusual?
Well, it's unprecedented.
Okay.
And as far as I'm trying to dig deep, because I've never witnessed this situation, and so I don't know if the case aspect of parliamentary procedure, I know your amendment is germane because it's to the original strike and insert. But the technique is very confusing, because would your amendment be exactly as the original House bill, or are there little changes that you've had? Because it's the exact version.
My goal was to get back to the House.
So if your amendment would pass to the strike and insert of the Judiciary Committee, and then there would be another vote on the strike and insert of the Judiciary Committee, that would actually be, you would have 2 votes on the original, you would have 2 votes of the House bill necessary in order to get it done. This is very clumsy.
Unprecedented.
Yeah. So I'm just wondering why not speak against the judiciary strike and insert and for the original bill and then vote it that way.
Well, the other reason is it still leaves us leaves me an opportunity to amend what's left.
Oh, so you have other amendments that you're going to...
I might. I don't know.
If this one fails, you have
I don't
other
have any filed.
Yeah, but if you haven't filed it, I don't know. I think you
Yeah, I
missed your
think
time.
That would be unprecedented wrong, correct?
But yeah, that's according to rules of the, as
So-
far as laid out by the Senate President, that we have to have our amendments in by an hour before the floor session.
Right.
Thank you. I mean, it's caused a lot of confusion of where we are, and I
Yeah.
appreciate you
You're welcome.
clarifying that. Thank you.
Is there further discussion? Senator from Jefferson.
Thank you, Mr. President. Would the Judiciary Chair yield for a very brief question?
Will the senator from Morgan yield for a very brief question? Senator yields.
There's no guarantee you get a very brief answer to your very brief question.
I might say the senior senator from Berkeley does bring up an interesting point, and he is absolutely correct. Mr. Chairman, this was obviously in our committee. We were all there. We did debate this in the Senate Judiciary Committee for between 2 and 3 hours minimum, did we not?
I think it was probably that.
I think we were there 4.5 hours that day, but we did have a couple other bills. My question, this bill in either form does create a cause of action. That's what this bill does. Am I correct?
You disagree? I disagree with that as to the Senate strike and insert. It certainly doesn't create a cause of action for damages. We lock that out. It does permit people to seek injunctive or declaratory relief. So if I guess you consider that within the ambit of a cause of action.
Right.
Yes.
Then you're just one sentence ahead of me. The major difference between the and cause of action by way is lawsuit. The major difference between what the senator from Kanawha is attempting to go back to the House version, which would eliminate the work of the Judiciary Committee, one major thing in 2 parts, that the Senate Judiciary Committee removed monetary damages and attorney's fees. Those are both in the bill as it came to us from the House, but they are no longer in the strike and insert amendment from committee, correct?
That is correct.
Okay, so that is a major difference. And I won't ask you to agree with this, but I'll just make a statement for the members. Let
me revise my answer
Please.
slightly. The Senate strike and insert amendment does not have anything in it about permitting recovering attorney's fees and costs or damages. I think it was in the, I'm told that it was in the House that the House bill just limited it to attorney's fees and costs. And we removed that. That's what the Senate Judiciary.
My final point, and very briefly, is that BRIM coverage, thank you, Mr. Chairman, BRIM coverage for counties and cities, if it's a discrimination suit or whatever, BRIM has told us they will not cover that. So counties and cities will have more exposure or complete exposure in what the House sent, and we've attempted to limit that. And I believe one of my reasons for favoring and voting for the strike and insert was because of the lack of BRIM coverage for these types of lawsuits. So I do urge rejection of the amendment, and let's stick with the work of the judiciary.
Further discussion. The senator from Upshur.
Thank you, Mr. President. Would the gentleman from Morgan yield?
Will the senator from Morgan yield? Senator yields.
Yes.
Thank you. That raised a point there, and I remember we had this discussion. And so, as it relates to attorney's fees and expenses, those are non-recoverable. Is that right in the underlying strike and insert?
In the Judiciary Committee strike and insert, the only relief that is specifically mentioned is injunctive or declaratory relief or as a defense in a judicial administrative proceeding. Yeah, nothing about monetary damages, attorney's fees, or costs.
And so if someone did find that their religious beliefs were substantially burdened, or they thought so, and they fought out a protracted legal battle, which I can tell you I've been involved in lawsuits, easily runs into tens of thousands, if not hundreds of thousands of dollars, in defense of their religious rights, and they prevail in that case, this does not provide for them to be reimbursed for their reasonable attorney's fees and other costs associated with defending their rights?
This does not. Specifically, this does not. Although, now I will say to you that under our Human Rights Act and under federal laws that protect against discrimination, many of those statutes allow causes of action for discrimination on the basis of religion, and so, and those statutes do allow attorney's fees.
But an action that was, I'm sorry?
In many cases.
But an action that was commenced and could only be pursued under this particular act, a person could have an enormous outlay of expense to defend their rights and not have an opportunity to recover the damages, or I should say the costs associated with defending their rights?
That is correct. This is, to be clear, in the version, in the strike and insert before the body, I think its applicability is limited to being a shield as opposed to a sword.
And so in the House version, which is what we're trying to return to with the strike and insert to the strike and insert, would a person be able to sue and obtain, in addition to reasonable attorney's fees, expenses associated with the suit, would they be able to sue and receive damages far beyond were there compensatory or pecuniary damages associated with the House side?
You're talking about the final House bill?
Yes.
In the final House bill, it was just attorney's fees and costs. I think the original House bill had broader damages, but I think they were removed in an amendment during the process.
And so in the House bill, the protections were kept so that a person who found that their religious freedom was substantially burdened would have an ability not only to defend those beliefs, but not to get stuck with a bill that could potentially be in the hundreds of thousands of dollars to protect a right that they fundamentally have.
The Senate strike and insert does not mention attorney's fees or costs. The gentleman, Senator's correct.
But the House version, if we return to the House version, then we offer people the opportunity not only to defend their religious freedom, but to not have to suffer the burden of that defense if they prevail.
And to have the trial bar do what it does. Yes, sir.
Precisely. And this raises a question for me, and I think throughout the document, and as we discuss this in Judiciary, quite often when things come over from the House and they land in Judiciary or in Finance or Education, the various committees that I'm on, it's entirely common to do a strike and an insert, and quite often it's very apparent how the strike and insert improves upon the document that's sent over from the House. We clearly have better drafters over here. I think we all appreciate that. And typically, though, we don't turn it on its head. And my concern with the strike and insert in this case, the underlying strike and insert that came out of Judiciary, is that in many ways it did turn things on its head from what came over from the House. And this is one example of that I think really stands out, that the House provided for relief beyond injunctive relief and declaratory relief, which neither compensate in any way for the time and the effort and the expense associated. I'm also concerned about other areas, and so if I could...
Is there a question?
Yes, there is. If I could you perhaps maybe offer up some detail in specifics of what the weaknesses were in the House bill, aside from that particular, we would assume that was a weakness since it was stripped out in Judiciary, or at least that it's the opinion of the Judiciary Committee that that was a weakness. What other weaknesses did the House bill have that it was necessary for the Senate Judiciary Committee to correct?
Sure. I'll give you my opinion only, and as my good friend from Upshur knows, I'm just one of 17 members of the committee, so others may have different views of it. But let me say first, I guess it's somewhat complimentary to say that sometimes we do a com sub or a strike and insert that improves the bill. I understand the senator from Upshur doesn't view this judiciary strike as an insert amendment as an improvement, but it's in the eye of the beholder. I do. I think the Judiciary Committee strike and insert amendment is better than the House bill for a couple of important reasons, some of which I've mentioned. First of all, the House bill does not contain a definition of substantially burdened. I think if you're going to write statutes that give courts or purport to give courts direction about what to consider in litigation, and you use terms like substantially burdened, it's important to give a court a definition as to what that means. And so the House bill didn't have one. We found Pennsylvania's Religious Freedom Restoration Act and used that. I think the section 6 in the Senate strike and insert, we haven't talked about that much, but let me just tell you why I think that's an improvement over the House bill. And it's not in the House bill, but to the extent that anybody ever talks to me about this in my district, it is this. People, parishioners who have a fear that their church or their pastor is going to be required somehow to perform marriages for same-sex couples. They don't want that. Now, I will say and concede here on the floor of the Senate, I don't think under the United States Constitution or the West Virginia Constitution that that is possible. But to the extent that it is, I don't see any harm in putting it in the bill and making it clear for the people there are people who worry about that.
Sorry, no, on that particular point.
Sure.
I agree with you that the U.S. Constitution as well as the state Constitution would preclude that. And so, as a point of clarification, would you agree then with the statement that that's essentially superfluous? It serves no purpose in this document because the protections are already there and fully existent?
Well, you could make that argument about everything that's in this bill because the strict scrutiny, compelling interest test is, as I understand it, the law of West Virginia now. So, I mean, and there are people who have expressed opposition to this bill who said the whole thing is superfluous. And quite frankly, it's hard at some level to disagree with them if in fact, all we're doing is codifying a test mandated by constitutional law.
And I'm sorry for interrupting, but if you want to continue.
Well, let me just go on that point, though. I don't see harm in doing it. We codify, we put things in the statute all the time that aren't necessarily brand new law. They're codifications of constitutional principles or rights, and it's certainly okay to do that. It's certainly okay to do that. And so to the extent that that's what this bill does, I don't see any problem with doing it, either in Section 6 or in the bill as a whole. And the Section 7 I mentioned is, I think, an important difference between the original House bill and the Senate strike and insert, in that I certainly hope that to our friends, to those West Virginians who worry about something we enact becoming a tool utilized for discrimination, that this will be a salutary or comforting message, that is not the intention of this legislation. That's why I like to have it in there. And I think its presence improves the House bill. I recognize fully that my good friend from Upshur does not, and we'll just disagree on that. But do you have anything?
To that section, and so you were addressing the strengths, I guess, or the differences, the weaknesses in the House bill.
Yeah, otherwise, I think they're largely congruent.
So is there anything that...
In other words, I don't think there's a huge substantive difference between using the term governmental action or state action. I think governmental makes more sense because we are including municipal ordinances. So, you know, if you say state action, it's possible a judge could go off the reservation and say it doesn't apply to local ordinances because it's only state action. So I don't, you know, you may have a different view of that. I don't know.
My point in asking, in part, is that between the House version then and the Senate version, and actually not only compliment generally, I think the Senate version is laid out better in this case. The flow and the form of it appeals to me more.
Keep going, brother. I'm liking the sound of it now.
And quickly, if I could, you touched on a point that in West Virginia, strict scrutiny is the current standard.
I believe that to be the case.
Are you familiar with the Workman case in Mingo County that was decided less than 10 years ago?
No, sir, I'm not.
It was a case related to vaccinations, and we're going to deal with that here in a little bit. But in that particular case, the standard that was applied was not strict scrutiny, and the court specifically said that. In fact, the standard that was applied was a rational basis standard. And so in 2007, we have a rational basis standard being applied in West Virginia, not strict scrutiny.
Well, I happily stand corrected.
And so we maybe do have a valid reason for...
To call it restoration instead of protection?
Well, calling it restoration instead of protection, but also recognizing that perhaps this is something new and does present a higher bar than what we currently have.
It seems to be, and I'm sure the gentleman, and I know the senator from Upshur to be well-versed in all this, and I know you've read that Everly case, and I'm hoping that you would agree with me that appeared to be a strict scrutiny test for the juror who didn't want to sit on a jury and felt like it was an infringement upon his faith.
I would, but what I would point out is that the Everly case, if I'm not mistaken, was decided before the Smith case was decided in 1990 and essentially turned that standard on its head. And so what we see is in 66, I believe, we have the Everly case decided on strict scrutiny, and then in 1990 we have a case that says that's no longer the standard. And that was the kickoff, as we know, for federal as well as 21 states legislatively and another 7 states through judicial action to restore the strict scrutiny test that has not yet been restored in West Virginia.
And, well, I'll agree. And let me say this, so I'm on the record for this. I don't have any problem with codifying this test, whether it is overlaid completely and congruent with constitutional law as we have it, or whether it raises the bar, as the gentleman says, a little bit from where we were, apparently with some decision involving immunizations. As the senator from Upshur knows, West Virginia is one of only a really small number of states that don't recognize separately in statute some sort of religious exemption for immunization.
And that case actually specifically addressed that, and again, we'll deal with that here shortly, I think. But that is true. Do you believe that if this amendment were adopted, the strike and insert offered by the gentleman from the 8th, that it does severe damage to the underlying strike and insert that came out of the Judiciary Committee? In some way, does it harm that or make that...
Substantially burden it?
Yes.
I don't know if I go so far as to say severe damage. I really, really like, and I think that's those sections 6 and 7 that are in the strike and insert are important.
Important, but they don't really carry a function, if I understood what you said before, other than a statement.
But on something like this, where the rhetoric at times can get, the temperature can get raised, I think it's important to make a statement. And to make a statement that what you do or don't do, so that what you do or don't do as a legislative body is not misinterpreted. Either honestly or intentionally to create an impression that the legislative body is doing something that it has no intention of doing.
Do you recall in Judiciary we had a discussion related to the use of the word individual versus the use of the word person?
I do.
And that was a very significant difference, as it turned out.
The difference between the two is related to the scope and breadth of persons covered, who is covered under the Act.
Persons means that it's a lot broader than a human being.
Right. And the original House bill had persons in it. The first draft of a strike and insert that we started with in the Judiciary Committee used individual, which I would concede would make it narrower in scope. But ultimately, you prevailed on that point, and we yielded, and so we're using person throughout in this.
That's true, and I do have a concern, and I think it's a legitimate concern as it relates to the use of the word person throughout, and that is in Section 11C7, starting on line 4, about halfway across, we have, rather it is the sole intention of the legislature in enacting this article to codify the test and standard of review under which governmental actions are to be judicially reviewed when those small typo there, are alleged to be substantially burdening to one person's sincerely held religious belief. And I believe, and I could be corrected perhaps, that when we use the predicate adjective there in front of the word person, one person, in that section at least we are now declaring that it is the intent perhaps of this to go back to that individual standard because it uses the word one person.
My guess is it's more likely a word processing glitch from maybe it said one individual before and it didn't get changed. But let me ask this. If we would change that to a person, just the indefinite Article A, would that relieve all your concerns about this section?
It wouldn't, but it actually draws much attention to many of the concerns that I have, which is with both that section and particularly with 11C6 and no government entity may compel, and then we have a fairly long list there. I believe that long list that we've included there actually runs afoul of the Establishment Clause of the United States Constitution, because we're identifying within there the certain types of things that we consider to be legitimate religious activities, functions, institutions, places, and so on, and by specifically including such a list, we may be precluding anything that doesn't fit that list as being covered by the statute.
I don't share the gentleman's concern on that. I think that it's clear, it should be clear that that is not meant to be exhaustive or exclusive.
I think, too, and the same issue arises whenever we look at 11C3 in that definition of substantially burdened. There are 4 separate definitions of what substantially burdened means, and in virtually every case, it uses language like mandated by a person's sincerely held beliefs, or a specific tenet of their particular beliefs, or engage in activities which are fundamental to that person's beliefs. And the case law, as I understand it, that relates to the RFRA laws is fairly clear that it's a very broad and expansive definition. Yep.
First of all, these aren't exclusive, and they're in the disjunctive, and it comes from the Pennsylvania statute, the Pennsylvania Religious Freedom Restoration Statute. But I don't know. I've got to say, I disagree with the gentleman. I think they're pretty broad. Constrains or inhibits conduct or expression mandated by a person's sincerely held religious beliefs. That's pretty broad and expansive, in my opinion, and it's certainly not limited to any particular denomination or sect or even the implication that a person would have to have one, just that it's a sincerely held religious belief.
I thank the gentleman for yielding, and I really didn't intend to necessarily go that long, but it's an interesting conversation.
My pleasure.
I rise in support of the strike and insert offered by the gentleman from Kanawha County. from the 8th District. And my reasons for it are, I do believe that the underlying amendment, strike and insert amendment as it came out of Judiciary, does leave some constitutional questions in order. It erased the ability of a person who has been substantially burdened to even recover the fees associated with defending their rights, which I think is a very important. If government's going to trample upon your rights, and I've already heard some argument related to how could the cities afford to defend against these cases, how can a person afford to defend their rights if they have no hope of even recovering the cost of defending their rights? You know, the city here is the actor acting under the collar of law. They're acting under the power of somebody else's tax dollars that come and fund their legal campaign potentially against a person whose rights are being infringed, and yet the person whose rights are being infringed is expected to foot the entire bill. The mayor doesn't foot the bill whenever he infringes upon somebody's rights. The governor doesn't foot the bill when he infringes upon somebody's rights. He requires the taxpayers to do it. The mayor requires the taxpayers to do it. The county commission requires the taxpayers to do it. But when the taxpayers' rights are infringed upon, this bill specifically precludes the ability for that individual to even recover just the cost of defending their rights. And so by going back to what the House sent over, if nothing else, we preserve what should be, I think, fundamental in anybody's mind, that you shouldn't have to defend your rights at your own cost whenever they are being trampled by the government, by the state. And so I would strongly urge the adoption of this amendment. I think it actually is a much stronger bill. We were never actually given the opportunity in Judiciary specifically to start with the House version. And so we didn't have an opportunity in many cases to discuss any of these strengths and weaknesses of the House version. The House version, I think, is a better bill, even if it's not drafted as beautifully as the Senate version. It does a better job of protecting the religious rights of the people of the state of West Virginia, and I urge its adoption. Thank you, Mr. President.
Is there further discussion? Senior Senator from the 16th.
Mr. President, point of inquiry to you. First point is how many other amendments are actually in line after this one?
There's one more.
There's no more?
There's one.
One more. And so my question is that if this amendment to the strike and insert actually passes, then would the second amendment that's pending be out of order and therefore not be allowed to be offered up?
Chair believes it would be out of order, but we would allow a
So it would be
substitute
out of
amendment.
order? And I'm just wondering if this is the attempt in order to try to prevent that amendment from getting in here.
No. We'd allow a substitute amendment.
What's that?
Allow a substitute amendment, which I understand is prepared.
Thank you.
Is there further discussion? Further discussion, I recognize the junior senator from the 8th to close.
Thank you, Mr. Chairman. I honestly never meant for this to go on this long, and I'm not going to go on long. Opinions are strong on both sides of this issue. I like the House bill better for the reasons that the gentleman just told us, same reasons I have. This is a highly charged issue. There's considerable fear all around. There's misinformation and, as I said before, hyperbole on both sides. I would only ask that my colleagues here think about your constituents, sift through the hyperbole, and vote for what you think is correct. Thank you, Mr. President.
The junior senator from the 8th requests the yeas and the nays as their objection. Chair hears none. The question before the body is the adoption of the amendment by the junior senator from the 8th to the amendment by the Committee on the Judiciary. All those in favor will vote yea. Those opposed will vote nay. The clerk prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the results on this question. 13 yeas, 21 nays, 0 absent, not voting. Less than a majority of those present and voting having voted in the affirmative, I declare the amendment to the amendment rejected. Are there further amendments?
Yes, sir. Senators Palumbo and Stallings move to amend the amendment
The
on
senior
page
senator
2.
from the 17th.
Thank you, Mr. President. I ask unanimous consent to explain the amendment in lieu of having it read.
The senior senator from the 17th requests unanimous consent to explain the amendment in lieu of having it read as their objection. Chair hears none. So ordered. Senior senator from the 17th.
Thank you, Mr. President. This amendment would simply indicate that the bill would not apply or take away from any non-discrimination or child vaccination laws or ordinances that are currently on the books in West Virginia, either at a state level, a county, or municipal level. And I think that the proponents of this bill, and my friend from Morgan, have indicated clearly that the bill is not intended to do that. And with all due respect to the senator from Morgan, subsection 7 of this bill, I think, maybe arguably makes that point, but this amendment would very clearly make that point. It would make clear that this bill could not be used in any way, shape, or form to try to invalidate or not comply with non-discrimination or child vaccine laws. Ladies and gentlemen of the Senate, I want to make sure you know that adoption of this amendment would not mean that those laws couldn't be challenged, because they still can under Article 3, Section 15 of the West Virginia Constitution. I mean, we have our religious freedom guaranteed by our Constitution. This amendment would just make clear that you could not use this new law, the Religious Freedom Protection Act, to say that a non-discrimination ordinance or a child immunization ordinance violates your deeply held religious belief. You can still do it under the Constitution, but you cannot use this bill as a sword. And that's been a big discussion, whether this bill is a sword or a shield. This will make clear it cannot be used as a sword to try to invalidate those ordinances. But once again, you still will have that right. If you're inclined to want to discriminate in West Virginia, you can still use Article 3, Section 15 of our Constitution to do your discriminating. You just can't use this bill. And I think it's very clear, if we don't put this amendment in this bill, what is going to happen in West Virginia is going to be the exact same thing that happened in Indiana. And there's been some discussion about what happened in Indiana on this floor. My friend, the junior senator from the 8th, pointed out that Indiana had a record year in their convention and tourism business last year. And while that's true, it also should be pointed out that from March, when the law was signed into law, to December, their bookings were down 95,430 room nights versus the same period in 2014. And among out-of-state organizations, they were down 182,437 nights. I mean, prior to March, before the law went into effect, they were way up. But after the law went into effect, they were way down. Overall, it ended up being, they had a decent year, but as their marketing and tourism person said, you could argue that we only achieved 1/3 of what we could have done, because as a nation, tourism was up 2.9% and they were up 1%. So there's no question, and I'll just read this quote too from the president and CEO of Visit Indy. He said, there are people who are convinced that there was no impact from RFRA, and there are people who are convinced that the sky fell and that we lost it all. And the truth is neither one of those. He said, we've continued to have convention business, we continue to get convention business, but there absolutely was an impact. There absolutely was an impact, and that impact was decidedly negative. That's not his quote, but that impact for Indiana was decidedly negative. Also, there was a study by a national travel research group that ranked Indianapolis second among 40 major convention cities for receiving bad publicity that may deter event planners from choosing their location. So there's no question what's going to happen in West Virginia if we don't make clear that this bill cannot be used to discriminate against people. The black eye we're going to get from this state is going to be large, it's going to be wide-reaching, and it's going to be well-deserved. We need to stand up in West Virginia and make clear that this bill is not going to be used for discriminatory purposes. I appreciate the efforts of the senator from Oregon, my good friend, and subsection 7 of that bill does that, not in a clear way, but attempts to do that, I believe. And I believe in my heart that the senator from Oregon does not want this bill to be used in a discriminatory manner. But this amendment, adoption of this amendment, will make that crystal clear. And again, as I said, in the Senate Judiciary, the proponents of this bill said they don't want to discriminate. They don't want to use this bill as a tool to discriminate. Well, let's put it in the bill then. Let's put it in there. Let's make it clear that it's not going to be used in that manner. And again, just to wrap up, this amendment will not mean that you have no ability to challenge local non-discrimination ordinances or no ability to challenge child vaccination laws, because you still have that right to do so under our state constitution. It just means you can't hold up this bill and attempt to discriminate in any way, shape, or form. So I urge its adoption.
Is there discussion? Senator from Boone.
Thank you, Mr. President. I'll rise in support of the amendment as well. Even though we may be one of only 3 states that allows for medical exemption only, there are other states that are wanting to look like us with regard to our good immunization bill. I applaud and again support clearly delineating that you cannot be substantially burdened by the fact that you need to get vaccinated in order to go to school. It's a good public health amendment, and I fully support it. Thank you.
Further, Senator from Ohio.
Will the gentleman can all yield?
Senior 17th yield. Senator yields.
Senator, I have a question for you. As you know, I've struggled a little bit with this legislation, and I think I have a good grasp on what the bill does. But we have your amendment before us now. And what I'm not as familiar with are all of the anti-discrimination ordinances. I know there's a number of them around the state and, of course, around the country, but I'll focus just on West Virginia since that's our concern. And I acknowledge that there's been a lot of misinformation on both sides of this issue, and I'm trying to sift through that as best I can. I believe there's potential for individuals to abuse both of these things that we're talking about. I think there are individuals who will potentially attempt to abuse RFRA for purposes that it's not intended to do, but I think there could be potential that folks would use anti-discrimination ordinances in a way that they're not intended. And so I'm going to throw out a little bit of a hypothetical here. One thing that I heard, and I think the senator knows that I'm sincere in my question. I don't mean to further any of that misinformation. Is it possible for a non-discrimination ordinance to allow someone who claims to be transgender, a male who claims to be transgender, to use a female restroom?
To the senator from Ohio, I do not believe so. I mean, I've heard these hypotheticals thrown out over the last couple weeks as we've been considering this, and it's my understanding that in no place in West Virginia has that issue come up, and I'm not aware of that being an issue, anywhere in the country. That's not to say it hasn't, but But I'm not familiar with anyone attempting to use a non-discrimination ordinance in that manner.
And I would agree with you. I'm not aware of any situation that's occurred as of yet, but I guess I'll rephrase my question. Can you tell me with certainty that it's not possible for an anti-discrimination ordinance to be in that way?
Well, I can't tell you with certainty how anything is going to play out. I mean, I do not believe that that's what non-discrimination ordinances are put in place to allow. I don't think that's what they're intended to do. And my suspicion is they could not be used in that way. But can I tell you with certainty? No, I cannot tell you that.
Okay. Thank you, Senator.
Further discussion? Senator from Morgan.
Thank you, Mr. President. I rise in opposition to the gentleman's amendment, or the amendment by the gentleman from Senators from Kanawha and Boone. And reluctantly, because the senators who've offered this are getting to the point that I'm trying to make. I think only that the amendment goes slightly too far. The amendment says this article does not apply to any state, federal, local law, anti-discrimination laws or ordinances, and this article does not apply to any federal, state, local child health laws or ordinances. The fundamental purpose of the bill, as I understand it, is to establish the test, to codify the test, under which religious rights and other rights of others, are balanced when they come into contest, and not to determine in advance winners and losers. I think the amendment by the gentleman from Kanawha, senators from Kanawha and Boone, takes that a step farther. And it does determine winners and losers, because it makes the article inapplicable when it's a question of vaccines or discrimination laws or ordinances at stake. And so it ends, there would be no balancing. There would be no balancing to be done because it's preemptive. And so for that reason, I oppose the amendment. I think it goes too far in the opposite direction. Actually, I should say that the other part of that, where it says anti-discrimination laws are determined to be have a compelling governmental interest, I'm not offended by that, and I think probably that would be the determination, I would hope, that would be the determination of every court that analyzed one of those. You know, a court's gonna, if the state government, if this legislature or a municipality adopts and enacts an ordinance that provides for protection of people against discrimination, I can't imagine that a court would ever say that there's something other than a compelling interest. I think clearly there is compelling governmental interest in that, which under this religious freedom measure we have before us, without the preemptive part of the gentleman's amendment, without the first sentence, would be weighed within that balancing test. But for those reasons, and it seems as if I'm nitpicking, I apologize for that, but I oppose the gentleman's amendment, well intended as I know it is.
Further discussion? Senator from Harrison.
Thank you, Mr. President. I'll be brief. I know this issue's been heavily belabored. But you know, as I sit here, I think of so many bills we've addressed here in the past 6 weeks, which are solutions looking for problems. I've never heard of a case where somebody's religious freedoms were trampled upon in this state. And I wonder what we're doing. But the gentleman's amendment is an essential part of this bill if you want my support for it. Because I'm not concerned against the groups that have been raised so far, whether a transgender individual can go into a restroom. You know what I'm worried about is when there's nobody left like that and we start looking at each other. When a Catholic refuses to render a service to somebody who's of the Jewish faith. When a Protestant gets upset with an Episcopal. When somebody who wants to practice Sharia law which is something that strikes fear in the hearts of many Americans, that I got an email today, it's being practiced in 14 states. This law, without this anti-discrimination provision, can be used against all of us. Now, that's not what America's about. America is not about setting up tools for us to stab each other in the back with. America is about all of us being able to come together and live in freedom. And the First Amendment in our Constitution protects our religious freedom. No law shall interfere with our religion, and no religion shall interfere with our government. We've lived by that for more than 200 years. I said before, we're the longest standing national government in world history. Surely that means something to all of us. I strongly urge support of the gentleman's amendment. It's a good amendment. It's what everybody who's supported this bill says it's about. Not about discriminating against people. It's about religious freedom, the same religious freedoms we have now under our Constitution. Let's back up our words. Let's back up our words with our action and vote for this amendment.
Senator from Marshall.
Thank you, Mr. President. I, too, rise in support of the amendment, and for a couple of reasons. Number one, I've been watching and listening to this debate for some time over the last couple of weeks and across the way and here in Judiciary, and I've yet to hear one example, one concrete example of any kind that this is a problem of any kind in any nature, anywhere, at any time in West Virginia. One example where it's created that our Constitution that has been described as the strongest, even stronger than our own U.S. Constitution, doesn't afford adequate protection for those who want to practice religion. Not one. Not one. So is it a solution looking for a problem? Absolutely. The amendment offered by the senior senator from the 17th, clarifies clearly that this bill cannot be used for discrimination purposes. And folks will say it guts the bill. Well, then that's exactly why we need it. Because the proponents would suggest, without this, we can't discriminate. If his amendment passes, then we can't discriminate. Surely that's not something anybody in this chamber would support. Discrimination of folks of any kind in the name of our Lord and my God. It's wrong, Mr. President. And it does send a horrible message that West Virginia is not open for business. It has grave concerns. The majority leader shared with me yesterday some communications he got from the chamber that has grave concerns and great concerns about the bill as it's written presently, because of the fact that it does not have strong anti-discriminatory language in it. In fact, the letter I saw and he shared with me yesterday indicates the addition of anti-discrimination language remains a much-needed critical component of House Bill 4012. The absence of such anti-discriminatory provisions is problematic. We urge the Senate to reconsider its position on House Bill 4012. We have that opportunity here today to reconsider, to send out a message that, yes, West Virginia is open to business for everybody. Everybody. We reject this amendment, we will have a black eye. And we'll have worse. We will send a message to our children who are different, that they're not welcome here, and for the love of God, they may not want to stay here. You know, that is the biggest problem we have as a state. It's mostly a function of population. We don't have enough people. We surely don't have enough young people. But I think if you look at nearly across every college campus in our state, of our young people, of our future leaders, of our future population, they'll say clearly, don't pass this bill at all. But I assure you what they'll say. Clearly don't pass anything that doesn't clearly have non-discriminatory language in it. Nobody wants to live in a state that doesn't protect every one of us. That's all the amendment that the senator has proposed, is to clearly state that in this bill, in the name of God, you can't discriminate. And I don't know about your Lord and Savior, but I don't think mine would want to either, Mr. President. I urge the adoption of the amendment.
The senior senator from the 8th.
Thank you, Mr. President. I'm going to take my time with this and try to cover some points about where I'm at on this. First I want to thank the Judiciary Committee. I think they've done a fantastic job in looking at this and being very deliberate in the process. I think that this bill has deserved the deliberation of this body, and I think that we've got a great process here in the Senate and the legislature. When people have come to me about other pieces of legislation, they ask, what are you all doing? And I say, please give the process time, because this process is a great process. It's one that's open, allows debate, allows ideas to be floated and to be discussed. I kind of want to go off of what the Judiciary Chairman said. He said the intent by the Judiciary Committee is to ensure that this act does not allow discrimination. The intent. I've been called by a law professor at West Virginia University. And he called and he said, Senator, I'm trying to figure out the intent of the legislature, because in other states, they record their meetings, they record and write down their notes as to what their actual intent is when dealing with causes of action. In other states, they do that, so when judges deliberate on causes of action, they can know what the intent of us, the legislative body, was, so they can make a true and fair and accurate judgment. I think what's going on here, Mr. President, is the senior senator from the 17th, what he's trying to attempt to do is show in writing what the intent of the legislative body is. Trying to show and go that step to say that no one's going to come into the court and hold up this bill and say it can be used to take back vaccination laws that we're so proud of in this state. He wants that written in the bill, and I think that's important to be in the bill. I think the health and well-being of the citizens of the state of West Virginia is important. And I know the arguments. I know they're going to say government has a compelling interest. I know that that could be argued. And yes, it can be argued. But I'd rather not leave that up to some individual judge in some county. I'd rather have it written in that it is our intent. Because our intent is extremely important. It is looked at. In other states, it is researched. They have professors at law schools that sit there and all they do is research what the intent was in laws passed throughout time. Mr. President, we're trying to get intent, what we're trying to do in here. I don't think that's something too out on left field. I don't think that's something that's misguided. I think that's something that's important. And I think that if we're saying, and the Judiciary Chair is saying, that that committee's intent is this, then we need to write it down. So that whenever those research studies are being done, when they're referencing this, that we can know that this is exactly what the intent of the legislature is. I can't underscore how important that is, Mr. President. I want to talk about a few other things. I want to talk about the state of Georgia. Everyone knows the state of Georgia just passed a law similar to this. And I want to talk about how we are in a crisis in West Virginia. We're in a crisis trying to bring jobs to our state. Moody's said we're in a recession, I heard brought up earlier, here in the state of West Virginia. Well, I know that the senator from the 17th did a fantastic job of talking about what the ramifications were, but I want to talk about what the ramifications were per the Chamber of Commerce in the state of Georgia. Their Chamber of Commerce produced a study that said that if that bill had passed without this language that we're trying to amend here today, that it would cost the state would lose an estimation between $1 to $2 billion of money for the state of Georgia. So to say that putting intent in doesn't have ramifications, that's the cost of ramifications by the Chamber of Commerce in the state of Georgia, was that without putting a non-discrimination language in, maybe because of perception, but it would cost the state of Georgia between $1 to $2 billion in economic activity. We can't afford that in West Virginia, Mr. President. It's not something that we can afford to even risk. You know, I don't think this undermines the entire intent of the bill, at least I hope not, because I don't think the intent of the bill is to discriminate. I think the intent of the bill is to have a protection, a standard laid out in code, a test laid out in code. And if that's all it does, this doesn't undermine that test, Mr. President. It doesn't undermine that test at all. At least I don't see that it does. You know, we talk about the cities being sued, and I have to say that we look at this and we say in this amendment that you can't sue cities, this, shall not go against city ordinances. When Lewisburg, the city of Lewisburg, was considering a non-discrimination ordinance, the Family Policy Council went down there and said, I've got two words for you: litigation and legislation. Litigation and legislation. If you pass this, there will be litigation because of the legislation that we'll have passed. And it'll cost your city over $200,000 in defense fees. Mr. President, the threat of litigation is already there. It's already there for our cities throughout West Virginia. And I think that's wrong. I feel like we're kind of being used as pawns here to try to move that litigation forward. You know, when we talk about non-discrimination, everyone focuses on, gays and all that. Let's move from that for a second and talk about age, our senior citizens. Let's talk about sex, gender, male and female. Let's talk about race as well. This amendment protects those classes as well. They protect those classes from somebody that doesn't feel that they should serve a female or a female should hold a certain capacity. That's what non-discrimination protects. It protects people that are sitting there and say, I don't like that person because of the color of his skin, and try to find a way to rectify that. Mr. President, that's also covered in this amendment, saying that you can't do it based on discrimination. You know, whenever you talk about non-discrimination, everyone points to 8 cities, but I have to point to every other city in the state of West Virginia and every other town in the state of West Virginia. The thousands of those, however many there are, that have age, sex, and race protected, and we're trying to uphold that protection with this amendment as well. I don't think there's anything wrong with this amendment, Mr. President. I think this shows our case. This gets rid of that black eye. This allows us to keep businesses coming forward in the state of West Virginia. You know, I love the way that our Constitution is written in West Virginia, and just like the senator from Oregon, I learned how amazing it is, how well it's written, how great our religious freedoms are protected. And I'm so proud of that. I love being a West Virginian. I try to tell all my friends that are my age not to look at this, but to look at all the other things that make West Virginia great. And that our Constitution is one of those things. And I'm trying to tell them that West Virginia is a place that's welcoming and accepting and is a great state. This amendment just puts into writing everything that we know to be true. That we know that we're proud of our medical vaccination laws in West Virginia. We are. Matter of fact, we were so proud of it last session that we did everything we could to protect them. I remember working alongside just about all of you all for that. And this just says that you can't hold up a sheet of paper in court and say it's their intent to have a case, a cause of action against that. And Mr. President, we're proud to be welcoming to anybody in the state of West Virginia. And I don't think that we want to put anything out that would show that we're not. I don't mind doing all we can to protect people based on their religious beliefs because, Mr. President, they deserve to be protected based on those. But I just want it to be written down in this law. Our intent is to not create lawsuits throughout our cities against our municipalities. Our intent is not to discriminate against anybody, and that our intent is to uphold our great vaccination laws that we have in West Virginia. I hope that this body agrees, because it will be a sad day if it does not. Thank you, Mr. President.
Senior Senator from the 4th.
Thank you, Mr. President. I'll be brief. I know the hour is late, but this issue has been nothing but a struggle for me from the very beginning since it came to me. I've been in this legislature for 22 years. I've ran for office 32 years ago. I'm an ordained Presbyterian Church in America minister, retired honorably now. A lot of you may not know, and I just say Presbyterian, but we are a very conservative denomination. We actually believe the Scriptures to be inerrant, and a lot of traditions do not. I say that to say this. Sunday morning I went to church, and there's a young girl who works over here at the University of Charleston, who works with international students and with students. And we actually this Sunday, and sorry for the detail, but most will know, and I'm sure the senator from Berkeley will know, we were looking at what we called the Constantinian era. That means the church suffered dramatic persecution until the 300s, when Constantine basically declared the empire Christian. And for the first time in 300 years, our persecuted church was wedded to the state, or became involved with the state. And ever since then, this has been confusing for us, hasn't it, Senator from Berkeley? And I've always, in my tradition, believed, and I want to get to the story of the young girl in a moment, but that we don't need the state to accomplish our mission. We didn't have your help for 300 years, and in parts of the world we don't have it now. And so, as a Christian, I'm not compelled to have the state come and protect me. Now, I like that protection, but I don't like it's needed. But here's what she said to me. After that Sunday school lesson, she came up to me and she said, "Mike, what are you all about to vote on up there? Something that's going to discriminate?" And I said, "No, I don't think so, but I understand that's what you could believe about it, but I'm not certain." And she said, "Well, I work with kids and students and so forth that I've just jumped to the chase." She said, "Why would you vote for something that builds a wall between people?" And I just thought this was a very interesting thing. And I have said, and I've talked, and I know this is, I have said to people, and I've talked in great detail to some who are advocates of this, and I've basically said, what problem are we trying to fix? Is there something that's happened? And you heard of my line of inquiry. There's been no case. And, my sense would be that, I guess, I don't know what I'm going to do on your amendment because of the vaccination section. I recognize that. But I certainly do understand that, and I don't know if this is about politics or sincerity or what this is about. But my sensitivity to this has always been that, that as a Christian I would communicate that I'm not in a desperate position of needing you to help protect my freedom. I mean, the ultimate freedom of us is internal anyway, and it's not about all the circumstances. It should be. Obviously, I don't want to be taken out of here and put on a rack. I might be after this speech, but at the same time, I just testify that the Lord's with us. And, we don't, so I just don't want to build walls. That's when she said that, that's what hit me. She's over there today, working with international students and people of different persuasions, trying to do things to help reach them with the gospel, sorry to say that we believe in our church. And said, we just don't need more barriers. And I know that might be misunderstood. Maybe that's a miscalculation. But that's kind of where my heart is on this. So I just had to say that.
Further? Senator from Upshur. Senator from Upshur.
Thank you, Mr. President. I rise in opposition to the amendment. I just want to point out a few things related to this. The first thing I'll touch on is the vaccination argument, and I said I would do that earlier. And the same case, and it was decided, and it was related right here to West Virginia, a woman trying to use her religious views as a reason to not vaccinate her child, and that decision was decided not in her favor. And it was decided not in her favor using a rational basis review. And so that's what establishes that right now in West Virginia that is the standard. But that same court at the same time said, however, we do not need to decide this issue here because, and the issue was whether or not a rational basis review was the appropriate one, even assuming for the sake of argument that strict scrutiny applies, which is what we're talking about applying, even assuming the argument that strict scrutiny applies, prior decisions from the Supreme Court guide us to conclude that West Virginia's vaccination laws withstand such scrutiny. So the court was saying, even with this law in place, even with strict scrutiny in place, West Virginia's vaccination laws withstand that strict scrutiny. And therefore, the argument related to vaccinations is entirely without any basis whatsoever. This will not have any effect whatsoever on West Virginia's vaccination laws. The idea that this is going to give West Virginia a black eye, the question I would have is, does it give South Carolina a black eye? Did it give Tennessee a black eye? Did it give Kentucky a black eye? Did it give Virginia a black eye? Do we consider Connecticut to be a hotbed of racism and discrimination because they have a RFRA law? What about Rhode Island? Do we know that Rhode Island, is that some place we would think of as being a discriminatory state? Do we have such a bad black eye view of the state of Rhode Island? They have this law. This law is on the books by judicial decision in Massachusetts. In Illinois, they passed this as a legislative act. A law very similar to this law, even closer in similarity to the one that came out of the House. So the idea that this is going to give us a black eye, did it give such a black eye to those states? The answer is no. Did it give a black eye to the United States of America? Because we have a RFRA law at the federal level. We're the jewel of the world that everybody admires and envies. Do we have a black eye? Obviously we don't have a black eye. And the question related to the economic consequences of this. The two fastest growing economies in the United States today are the states of Texas and the state of Florida. And they compete with each other for which one can be the fastest. And they leave behind all the other states. No other states are anywhere near Florida and Texas. They are far beyond the rest of the states. And both of those states have a RFRA law. So has it hurt their economy? Can anybody seriously make the claim that having a RFRA law in the state of Texas and a RFRA law in the state of Florida has hampered their ability to see growth and job creation? It's a silly argument. That's the truth of that. It hurts vaccination not in the least. It cannot be used to prevent vaccination. It is not a tool to discriminate. It's a tool to protect the religious rights. And it does not cause anybody to have a black eye. It doesn't hurt economic growth. Those are the simple facts. We can look around the country and see the facts are available to be seen. Mr. President, I would like to have the yeas and nays on this vote.
Is there further discussion? Senator from Jackson.
Thank you, Mr. President. This issue's not easy. And I rise in support of the gentleman's amendment. I prayed for clarity, wisdom, and discernment on this. I don't think I've ever mentioned our faith in a debate in this Senate chamber, or in the House chamber for that matter. Even though, as the gentleman from the 8th said the other day, frankly, I heard our clerk say one day, that it colors and influences everything we do. And it should. It does and it should. I believe in the goodness of people. I want the poor to be rich and the weak to be strong. And when we build walls, we diminish that. To the aggrieved, is a shield against discrimination any different than a sword to perpetrate the act? I don't know. I've never been, to my knowledge, discriminated against. You know, I come here every day. And really, in my life, with a joy. And people even mention it, you know. They say, God, you always seem happy. And I am. Because what's inside of me is better than what's outside. I just think this sends the wrong message, Mr. President. I think we need to value the human dignity and the goodness in people. I don't want this to be used. And I know those who promote this do so with the best intentions. Everyone here is, I am just, you know, I never quote scriptures, but one of my favorite scriptures is to value others is better than yourself. And certainly, I do that here. And I don't want us to go down this path. I just don't. I work hard for jobs and opportunity. And for those reasons, I would ask that we adopt this amendment, and then we can vote for this bill, allow it not to be used for discriminatory purposes, to value the religious freedom and protection that we hold so dear, and to recognize the human dignity and goodness of people that are different than us. Thank you.
Is there further discussion? The senator from Upshur requests the ayes and the nays. Is there objection? Chair hears none, so ordered. Question now is the adoption of the amendment to the amendment by the senior senator from the 17th to the amendment by the Committee on the Judiciary. All those in favor will vote yea. Those opposed will vote nay. The clerk will prepare the machine. Has every member voted? If so, the clerk close the machine and ascertain the results on this question. 23 yeas, 11 nays, 0 absent, not voting. More than a majority of those present voting having voted in the affirmative, I declare the amendment adopted. Are there further amendments to the bill?
No, sir.
Not the bill be advanced.
Questions on the amendment as amended.
Yeah, the question now is on the amendment as amended.
Yes.
All those in favor will say aye. Opposed, no. The ayes appear to have it. The ayes do have it. I declare the amendment as amended adopted.